Good day, Crime Talk aficionados. That's right. It is Sunday, which means it is time for the weekly recap of all the top stories over the past week, the week of March 31st, 2025, all conveniently located in the weekly recap in one convenient location. Thanks for watching. We'll see you next time. And remember, the Constitution matters.
All right, lawyer.
Anyway, kind of before we broke, we had a bunch of new stuff that came out in the Kohberger stuff, motions, right? There was still another stack of stuff that I still have to go through. And then on top of that, that's right, we have this new big stack here as well. But I'm going to go through it quickly, ladies and gentlemen, but there's a lot of big news in the Bryan Kohberger matter, all right? So first, the prosecutors have unveiled an essay. That's right, a college essay from alleged murder suspect Bryan Kohberger that allegedly shows he knows his way around a crime scene, according to some new and recent filings. In the paper written back in 2020 during a finals for a 300-level criminal justice course, Bryan Kohberger describes how crime scene investigators use fiber-free overalls, gloves, and booties to avoid contaminating the location with their own DNA and fingerprints. Now, at the 1122 King Road address where the alleged murders took place, police have revealed little evidence aside from a K-bar knife sheath found under one of the victims that allegedly has Bryan Kohberger's DNA on the snap. Now, before the FBI identified him as the person of interest, though, investigators used genetic genealogy. His name was unknown to the detectives. Now, he went into other aspects in this paper regarding crime scene investigation, but repeatedly referenced measures police should take to protect the location, shared his thoughts about circumstantial evidence, identified domestic partners as potential suspects, and warned that crime scenes could be staged. Now, prosecutors are going to talk about this when they bring up the lack of forensic evidence left by the killer. According to people familiar with the case, they're going to say, look, how much he knew about a crime scene. He talks about wearing these fiber-free clothings. Now, Kohberger mentions the fiber-free overalls, shoe covers, gloves, hair nets, and more when talking about the protective gear an investigator should wear to avoid the contamination of the scene. Now, Bryan Kohberger purchased a mask months before the Idaho students were savagely murdered inside their off-campus home. And the surviving housemates, Dylan Mortensen, told police she saw a man wearing a same kind of mask around the time police believed that Madison Mogan, Ethan Chapin, Kaylee Gonsalves, and Zaina Knodel were all murdered back in November of 2022. Now, Kohberger desperately wanted his Dick's Sporting Goods purchase to be inadmissible in the upcoming trial, but the new court documents reveal prosecutors have insisted upon using the records because it could prove crucial to their case. Now, the relevance of this information is that Bryan Kohberger purchased the masks from Dick's Sporting Goods back in January of 2022. This mask is the same type of mask described by DM that she witnessed worn by the male in the house on November 13th of 2022. Now, a search of the Dick Sporting Goods current offerings reveal there are 41 variations of this black mask or ski mask available, and it's not clear which one Bryan Kohberger exactly purchased. However, Kohberger's legal team has already tried and failed to have that critical DNA evidence and Amazon shopping history tossed from the case. The K-bar, the brown leather knife sheath, I guess I should be more accurate, featuring a United States Marine Corps SEAL, just like this one I just happened to get, back in 1988 when I went to boot camp. You really can't see it's a little faded here because it's all broken in, but there's a little Eagle, Globe, and Anchor. That's just the way they make them. That's the way they've been making them for, the last 80 years, ladies and gentlemen. Nothing changes on them. Anyway, they found that little sheath, all right, the little knife sheath. And, look how long the knife actually is, ladies and gentlemen. I mean, that's going to hurt. That's going to hurt. Anyway, that sheath was found next to Mogensen's body in the bedroom on the third floor of the home. Now, there's been DNA on the sheath that was traced back to Bryan Kohberger using the IgG, the investigative genetic genealogy, according to the prosecutors. And obviously, it must be because that's why the defense wants it out. Now, while the murder weapon has never been found, Kohberger's Amazon shopping history reveals he bought a K-bar knife sheath and a sharpener from Amazon back in March of 2022. 8 months later, on November 13th of 2022, investigators believe this same type of knife was used to murder the 4 university students. Now, following the murders, Kohberger's searched to buy a replacement knife and sheath, according to the prosecutors. Elsewhere in new filings is a 12-page assignment Kohberger submitted in 2020 while studying for his criminology master's degree. Like I said, the paper details in excruciating detail how first responders are expected to handle crime scenes. In the paper, he describes how surveillance footage can be circumstantial evidence, but may lead investigators in the right direction and to the apprehension of a suspect. This may be the work of a serial killer, though this is highly unlikely. Kohberger concluded in his paper by arguing that if all steps laid out are followed correctly, the defense should not be able to discredit the investigation and render evidence inadmissible. Now, prosecutors are going to argue it displays his immense crime scene knowledge. Now, obviously, with the trial getting close, the defense has been filing a lot of motions to get key evidence tossed from the case and to get the death penalty taken off the table. In new court filings, Kohberger is now seeking to also limit his bank records, including PayPal and Venmo records, and the bank records of the victim being presented at trial. It's not clear what the contents of these records show or the relevance they may have to the prosecution's case. The filing also points to a purchase made by Kohberger at a sportswear company, Under Armour, on June 24th, 5 months before the murders. Now, Mortensen's recollection of the masked man was vague, other than he had bushy eyebrows. And the state will attempt to use a selfie Kohberger took just hours after the alleged murders of the students as part of their case against him. The picture shows Kohberger smirking and offering a thumbs up to the camera. The selfie appears to have been taken in a bathroom with a shower as the backdrop. Now, Kohberger wears earphones as a colored long sleeve shirt that's buttoned down to the top in this little picture there. Let's get to the motions. I mean, obviously, we know a lot of the facts if you've been following the case. All right. Between 4:22 and 4:24 a.m. on the morning of November 13th, Mortensen and the other surviving housemate, Bethany Funk, exchanged 17 frantic text messages and, basically saying they're freaking out and things of that nature. You can go back and watch the previous videos where we go through them line by line. Now, over the 3 messages, Funk's response: "Come to my room, run down here." Soon after seeing the intruder, Mortensen went downstairs to Funk's room, and the two went back to sleep. Now, Kohberger has offered so far a vague alibi for the night of the murders, claiming that he was out just driving around looking at the stars. Now, no witnesses have been endorsed to corroborate that testimony. So the only one that could really corroborate that would be, Bryan Kohberger. Do you think he's going to take the stand? I don't know.
Next on the docket, Luigi Mangione. He's having a bad day. That's right. The Trump administration is taking the rare steps in seeking the death penalty against Luigi Mangione for his alleged cold-blooded killing of the United Healthcare CEO Brian Thompson, pushing for what would be the first Manhattan federal execution in 70 years. Now, obviously, Luigi Mangione is accused of murdering Brian Thompson, who the prosecutor, the attorney general, in fact, said was an innocent man, a father of 2 young children, and this murder was premeditated, cold-blooded assassination that has shocked America, Pam Bondi said in her little statement. So after careful consideration, Pam Bondi has directed federal prosecutors to seek the death penalty in this case as they carry out the president's agenda to stop violent crime and to make America safe again. But Mangione's legal team shot back that a lawless Justice Department is trying to murder the 26-year-old alleged assassin for mere political reasons. While claiming to protect against murder, the federal government moves to commit the premeditated state-sponsored murder of Luigi. his attorneys put out in a statement. By doing this, they are defending the broken, immoral, and murderous healthcare industry that continues to terrorize the American people. New York State outlawed the death penalty in 2004, but federal prosecutors can still execute defendants if they convince a jury to unanimously sign off on the government-sanctioned killing. The feds last sought a capital punishment case in Manhattan in 2023 against Sayfullo Saipaz, who was convicted of killing 8 people and wounding several others after mowing them down in an ISIS-inspired rampage in the West Side Highway. But jurors couldn't reach a consensus on whether to sentence him to death, so he received 8 life sentences. I think the government's going to be very hard-pressed trying to get Luigi Mangione convicted based upon his popularity, his youth. But hey, you never know. You get the right jury on there. You never know what they will do, to say the least.
Next, the Karen Reed trial has started, and they are seating a jury there as well. 76 potential jurors said they had heard of the Reed case, and another 38 said that they had actually formed an opinion about the case. So nearly half of the first group of potential jurors told the judge they had already formed that opinion. So 76 jury members raised their hands to actually acknowledge that they had heard of the case. 40 had already formed opinions. 16 said they had already had bias or prejudice for or against either the defense or the prosecution. So you can say, adios, we're out of here. So as of today, Wednesday, 2 jurors were seated and 2 other jurors were seated on Tuesday. The court is looking to get 16 jurors. 12 will be the deliberating jurors, and then 4 alternates just in case, because the trial is supposed to go several weeks. Now, the judge also gave a ruling yesterday, and the judge said the prosecution would be able to call Judson Welcher, a biomechanical engineer and accident reconstructionist, as a witness. The court noted Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert, the judge puts in an order. And his report demonstrates that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented to the jury for their consideration. And things got a little weirder. Now Karen Reed has 5 lawyers in the courtroom with her. Nothing makes you look more guilty than having 5 attorneys. Just saying, you got to be conscious of those things. And one of the jurors is Victoria George, who was an alternate juror in the first case. Now, I don't believe Ms. George has any experience doing criminal defense, so I think it's all big publicity stunt. And the reality of it is, it doesn't matter what she thought as a juror. Don't try your last case, right? It's like military. Don't fight the last war. You got to let it go. Okay, let me give you a quick example. All right. Years ago, young lawyer, I was asked to do a second chair on a homicide trial. I didn't do the first trial, but I read the transcripts. I got to do the retrial. And the lead attorney was like, hey, listen, man, the first trial, the jury got really wrapped around something here. The jacket was coming off, and we got to focus on that the second time. That's what hung it. Oh, okay. I mean, I wasn't there, but okay, I get it. I kind of see. Anyway, needless to say, we went to trial, client gets convicted, talk to the jurors and say, hey, you found her guilty. Why? And then they told us, like, she hiked through the snow, through the woods to get to, ex-husband's house with new girlfriend and, shoot everybody. Kind of a bad fact, right? And they knew who she was, and et cetera. I said, well, we asked about, well, what about the struggle with the jacket? And the jurors looked there and said, yeah, we just didn't see where you were going with that. Didn't really make sense to us. So the moral of that story is each jury is separate and distinct. Okay. And you need just one juror, take everybody down a path saying, hey, what about this? And you never know the personalities of that particular jury. So the moral of that story that I learned was don't try the last case, particularly in a retrial. And the prosecution knew exactly what the defense was going to do the second time around. That's why I keep saying, ladies and gentlemen, it doesn't get better for the defense the second time around. The chances of Karen Reed being convicted have gone up exponentially this time around. Throw it out there. She's entitled to the presumption of innocence. I would have found her not guilty of the first trial based upon the terrible performance of the prosecutors in their first trial. We'll see about this time. I think they got a much more experienced prosecutor who has literally, in my opinion, dismantled the defense case the second time around. Hence the reason my theory, it never gets better the second time around. So defense, don't go try your last case. You got to mix it up. You got to give them something that even the prosecution wasn't expecting. If you go with the same old trial again, guess what? She's going to be convicted. Anyway, for those who don't know, Miss Reed has pled not guilty to second-degree murder and other charges. And the prosecution says that she hit her boyfriend, John O'Keefe, with her vehicle outside of a home in Canton, Massachusetts during a snowstorm back in January of 2022 following a night of drinking. Her defense team has argued, however, that someone else is responsible for the death of her boyfriend and that Miss Reed is the victim of a great conspiracy and cover-up. Next, let's talk about Lori Vallow. That's right. A jury has been selected in the murder conspiracy trial for Lori Vallow there in Arizona. And this is what I thought was interesting about this. There appears to be 13 men and 3 women on the jury. Obviously, 12 of those jurors will ultimately deliberate and 4 will be alternates. What are the odds that she has a predominantly all-male jury or near-male jury? Pretty high. And why is that significant? Because we brought you the story the other day. The courtroom observer said that she was being very flirtatious and vivacious when it came to the male jurors, and that it was their job to protect her, right? So yes, her evil plan is working, I guess. We'll have to wait and see. Anyway, do you think she's going to be able to put a spell on all of those jurors like she did with all 5 of her husbands? It'll be interesting to see who wants to be number 6. Who wants to be number 6? Wouldn't that be a tale to tell? How did you meet your wife, Lori Vallow? Well, I was on her jury and I quitted her and we met, and well, now we have this long-term relationship. We'll never consummate the marriage, but at least we got rid of that deadbeat loser, Chad Daybell, right? Anyway, Lori Vallow is on trial in Arizona for conspiring to kill her former husband, Charles Vallow, who was killed back in July of 2019 by Lori's brother, Alex Cox. Now, Ms. Vallow has pled not guilty and said that she would be representing herself at trial. So far, she may be winning. Next, Taylor Schabusiness. I know you're saying, where do I know that name? I've heard that name before. Taylor Schabusiness. You remember her. She's the woman that was convicted of chopping up her boyfriend. Yeah. Well, she'd probably do it again, but it was in the courtroom this time. This time, she just scowled furiously at her attorney before she hit him. That's right. Take a look at this video. Convicted murderer Taylor Schabusiness gave an evil glance at her defense attorney, Curtis Julka, before she jumped out of her chair and attacked him today. Now, footage from the courtroom shows court personnel jumping into action and tackling the killer before she did any more damage to her attorney. Anyway, Schabusiness was back in court for a preliminary hearing after she allegedly attacked a prison guard and got charged. Now, she is serving a life sentence without the possibility of parole at a correctional facility after she was convicted of killing Shad Thyron during a drug-fueled sexual encounter in Wisconsin. Now, the attorney, Mr. Julik, asked to withdraw from the case, but the judge said, nah, he had to finish the hearing first. Anyway, following a 45-minute bank, Schabusiness appeared at the hearing from jail via video rather than in person. Now, like I said, she had previously attacked her legal team back in February of 2023. She attacked her then lawyer, Quinn Jolly, during a hearing before a deputy wrestled her to the ground in court. Now, the outburst came during the proceedings to determine whether Schabusiness was actually fit to stand trial. Anyway, Schabusiness was determined to be fit for trial and was found guilty of homicide, third-degree sexual abuse, and mutilating a corpse back in July of 2023. Now, she was convicted of killing Thyron in his mother's basement, telling the court that she liked the killing and enjoyed cutting off her lover's head. She said, quote, I was sucking and cutting at the same time. Schabusiness says in a video, I liked it. I didn't know what to do. Anyway, prosecutors said that Thyron and Schabusiness had smoked some meth in the basement of Mr. Thyron's mother's Green Bay home before Schabusiness strangled, decapitated, and dismembered Mr. Thyron. She then left parts of the body throughout the house and in a car. Remaining calm, however, Schabusiness allegedly told detectives that after Thyron put the chain around his neck, which she compared to like a dog choke collar, she just went crazy and started strangling him. She said that she could feel his heart beating, so she kept pulling and choking him harder and harder, claiming that he would not die as he just kept rebuilding into muscle. Anyway, asked what she did once she realized he was actually dead, Schabusiness stated that she had played with his body. Schabusiness told detectives that he had planned to take all the body parts with her when she left in her minivan, but she had gotten kind of lazy and was ill-prepared because, this murder was kind of random and wasn't really planned. Anyway, Miss Schabusiness attacking her attorneys, showing why she's a danger to the community, should never get out, probably fit to stand trial, just has some impulse control issues. Maybe that's it. Maybe just a little more social work involvement. Maybe would have prevented all of this. I don't know. Just having this conversation today. Some cases you feel more like a social worker than a lawyer. And I didn't sign up to be a social worker. You know what I'm saying? I don't know.